When a loved one passes away, sometimes it's unclear who inherits their property and valuables. This can get complicated if their wishes aren't clear. The probate process helps the courts sort through everything and decide who gets what. In the next few minutes, I'll discuss what exactly is probate and what counts as probate assets. Probate is the process by which someone's assets, debts, and affairs after they pass away are handled. In some instances, it does require going through the court system, and others it doesn't, but it does provide a process and a clarity under the statutes for someone to be able to handle the final affairs of someone once they have passed away. When someone passes away, it's important to determine whether or not a probate is actually needed. There are certain things that comprise a person's estate that are considered what we call probate assets, and there are things that fall outside of that. In Colorado, there's only 2 requirements for an actual probate in court. So that's why it's important to distinguish between those types of assets. 1, real estate. If someone owns land or any kind of physical real estate property, there is going to be a requirement to put that into probate unless it is jointly held with someone else at the time of their passing that would pass it outside of a probate. So if they're joint tenants, then that's not a probate asset. If they're tenants in common, then that would require a probate. The other part of that is if probate assets exceed a value of $82,000, there is a requirement in court to go into probate. Otherwise, you could do what we call a small estate affidavit for personal property collection. Now, normally things that one thinks of that have a high value after someone might pass, like life insurance, that normally has what we call a payable on death designation. The person who owns the policy prior to their passing names who they want to get it when they pass. Same thing, you could have retirement policies, you could have bank accounts, you could even have real estate that you pass outside of probate by designating a payable on death or a transfer on death beneficiary. So those would not be part of a probate proceeding. Also, someone could have a trust, and if they have property that's in the trust when they pass, that also is not considered probate property. So it is really important to distinguish between the two so you know, do we think we're going to have to open a probate and go to court, or is this something that we just handle outside of that? And that's important when you're also talking to an estate planning attorney to, if you want, try to avoid probate or know what assets may need to be handled in the probate after you pass. It's common when someone passes to leave certain debts, whether it's a mortgage or unsecured debt like credit cards, or very likely medical bills if there was an end of life that needed treatment. In the probate process, notice is generally given to creditors if the probate's initiated within 1 year of the date of the passing of the person. If 1 year has passed, there actually does not need to be notice given in the probate. There are certain types of creditors who are limited to about 4 months within the probate process if they are unknown. If someone knows about a debt and they open a probate and 1 year has not passed, then the estate does have to remain open for 1 year. Now, just because someone owed a debt doesn't actually mean they might get paid. There is a claims allowance process where, for example, if the estate doesn't have enough money to pay all of the debt, there could be an insolvent estate and the personal representative could try to disallow claims. Sometimes claims aren't actually valid. People try to claim that someone owed them money that they may not. So unless there is a valid contract or a judgment, that would be another basis to maybe disallow a claim. So they are handled in some form or fashion in the probate process, either through the claims period or it might have fallen out of that period and you may not have to deal with them at all. In some instances, if you're looking to make it easier on your loved ones after you pass, you may be able to set up an estate plan that bypasses probate. For example, you could set up a trust, and as long as your trust is funded where everything's in your trust at the time of passing, there wouldn't be a probate. You could also designate payable on death beneficiaries or transfer on death beneficiaries. That would also potentially just pass that property outside of a probate. In discussing that, there are certain tax implications for both yourself and potential estate and beneficiaries that are going to want to be discussed. So that's why it would be important to talk to an estate planning attorney as you're navigating that and how to best effectuate what you would like to happen with your property. If you're feeling overwhelmed by the probate process, you're not alone. Our team is here to help you every step of the way. If you have questions about probate assets or need help with estate planning, reach out to us to set up an appointment for a case assessment.